Hello there.
Hey,
Evening.
Bruce.
Evening.
I think someone has to ask the question. How many of us have voted? There's one. Any others?
For me, it's a tradition. I have to go on election day.
Yeah, I'm with you on that. Jim, how about you?
I think Jim is
I have
stuffed.
not voted.
Oh, he's silent. No?
I have not voted.
Mhm.
If I get a free moment next week, I will vote. Other than that, I'll be there on election day.
Good. Richard has already voted. He has no excuse.
Richard's voted about 10,000 times. I've seen City Hall.
Yeah. How about you, Jay?
I mailed mine in, the day I got it. So
Yeah.
just got it off my desk.
Yeah.
I
Did you
hope
get
they
the
got it.
confirmation?
No, was I supposed to?
I think you can confirm it. You go online, I guess. Richard can tell us about that.
Oh, really? Richard, is that true?
You're muted. You're muted.
Richard, you're muted.
Sorry about that.
All right.
So my answer was, you can go to trackmyballot.com, which
Yeah.
is a fairly reliable website. It's not 100% accurate, but no, we don't send out confirmations. We had in round figures, we mailed out approaching 7,000 ballots and we got 5,000 plus back. So we have enough to do without another mailing.
It's unbelievable how much paper there is laying around the clerk's office now.
Yeah. I like to think it's organized, Counselor, rather than just.
Oh, it is. It is. I'm not suggesting otherwise. Everything's in
had,
nice, neat rows, and people are processing the ballots. And,
We've had last week over 2,000 people vote at the senior center.
Wow.
Fun fact.
Good.
And that's on top of the 5,000 returns mailed.
True.
Wow.
And we have another week of it. So I don't know if we'll have another 2,000 a week, but we'll be north of 1,500.
Richard, I might comment that we're getting you from the nose to the top of your head. The camera is.
Is that better or worse? No, that's
Oh,
worse.
I like that.
How's that? Is this any better?
Yeah, that's good. The glare. Huh.
All right. I guess we can get started. Wait, there's an attendee. I see. 2, 3, 4, 5, 6, 7, 8, 9, 10, 11.
It was Councilor Tantar was over there.
Okay, 4.
There we go. Thank you.
There's still one man down, Councilor Devlin, I think. Well, why don't we, he may filter in. Why don't we call the roll?
Okay, for the council meeting of October 26th, Councilor Shan,
Present.
Councilor Tantar,
Present.
Councilor Vogel,
Present.
Councilor Wallace,
Present.
Councilor Zeid,
Here.
Councilor Devlin is absent. Councilor Khan,
Muted.
muted. I see her, but muted. We'll go back. Councilor Lane,
Here.
Councilor McCauley,
Present.
Councilor Connell,
Present.
Council President Argument.
Here.
Councilor Khan, are you there yet? We are going to mark her absent at the present moment, even though I see her, and Councilor Devlin is absent. Other than that, we have a full house.
Okay, do we have any late filed items?
I'm pleased to report none.
That's awesome. All right. Public comment. I see we have many people who have attended. If you wish to make a public comment, please raise your hand electronically. If you don't know how to raise your, there we go. They're queuing up. So I'll call your name. Please give your name and your home address, not your business address, your home address. And you each get 2 minutes. First is David Chatfield.
Can you hear me?
Yes.
It's David Chatfield, 67 Federal Street. As a member of the Newburyport Climate Change Resiliency Plan Committee. And I know that you're going to receive that link in your packet. And I would like to encourage the City Council to go through it, understand the vulnerabilities, and then really consider climate change in just about all the decisions that we make going forward. This is an incredibly serious issue. It has impacts, the financial impact, people impact on people's health, and impact on where people live. So again, I would like to encourage you to look at the resiliency plan and then consider it in all your future decision making. Thank you.
Thank you.
Thank you.
Next is Jane Snow, and I see that Councillor Devlin has now joined us.
So noted.
Jane Snow.
Good evening. Jane Snow, 9 Coffin Street. I just wanted to take a minute to thank the clerk and his staff and all of the poll workers. It has been really wonderful that they have made it so that we can all vote at a time that we all feel comfortable. And I know the number of hours and all the things that they've had to go through to do that, and it's so much appreciated. Thank you.
Thank you. Are there any other members of the public that wish to speak? Seeing none, I'm going to close public comment. We're still, Councillor Khan has dropped off. She must have had a technical problem. I'm sure she'll come back. We don't have the mayor in attendance tonight. She is on a break, on a vacation. I didn't receive anything in writing. I see Matt Coogan's in attendance, so if there are any questions for Matt Coogan, maybe we use this time for that. Councillor Shan.
Thank you, Council President. Matt, I did get a question today from a constituent asking about the diversity and inclusion task force. Just wondering if there's an update on that.
Sure. So we actually met last week, the mayor, with our selection team to review applications. We're in the process now of notifying those that have been selected to join the committee. That'll happen this week, and we hope to get that group together and launch their first meeting, hopefully next month.
All right. Thank you very much.
Thank you. Other questions for Chief Coogan? Okay, seeing none, let's move on. Consent agenda.
That consent agenda this evening consists of the approval of 2 minutes, September 29th and October 13th. There are 3 communications. Communication 275 is a letter from Jim McCarthy for public safety. Communication 276 is a letter from Alex Matthews to go to public safety. Communication 277 is the climate resiliency plan, and that is to go to planning and development. There are no transfers. The following first reading of appointments. Appointment 195 is Thomas O'Brien, 11 Mosley Avenue, CPA Committee until 11/1/2023. Appointment 196, Lisa Rowan, 17 Boardman Street, Disabilities Commission until 11/1/2023. And appointment 197, Constance Preston, 18 Atwood Street, to the Tree Commission until 11/30/2023. The following items are removed from their committee with this vote. Budget and Finance, Order 216, Order 217. Planning and Development, Appointment 187, Order 211 and 215. Public Safety, Ordinance 59 and Ordinance 62. And that is the consent agenda this evening.
Motion to amend, Mr. President.
To amend?
Yes, just to remove Order 216 from the consent agenda from
Yeah.
our Budget and Finance meeting. I don't think it's coming out, so.
Yeah, okay, you can just, all right, so that's removed from the consent agenda. Any other removals?
Can I just raise a point of order? I thought the clerk said that the the measures from Budget and Finance that were coming out of committee, that they're listed as, they were not supposed to be listed in the consent agenda. All right, because we had not met before the packet, so I didn't know what was coming out and what wasn't.
Oh, so you want to just pull
So
both?
I will need a motion to remove from committee on the floor
Okay.
when it comes to that time.
Okay, so I got it. So let's, we're going to strike the 2 automatic removals under consent, and we'll, you know,
Okay.
the chair will work on it when the time comes.
Thank you.
Very good.
Any other
Approve
changes?
as amended.
Yeah, is there a second?
Second.
All those in favor say aye.
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 Any opposed? Good, because that's unanimous. It has to be. All right, on to the regular agenda.
The regular agenda, second reading of the following appointments. Appointment 190, Elizabeth Valeriani, 29 Oak Street, to the Emma Andrews Library Board till 10/29/2021. Appointment 191, Elizabeth Watson, 53 Warren Street, to the same Emma Andrews until 10/29/21. Appointment 192 and 193 and 194 are all to Emma Andrews, all till 10/29/2021. They consist of Anya G. Elrod, 43 Purchase Street, Virginia R. Champy, 84 Purchase Street, and Donna Conway, 27 Marlborough Street. Those are the second reading of appointments.
Motion to approve on second reading altogether.
Second.
Second.
Any discussion? Roll call.
Councilor Shan,
Yes.
Councilor Tontar,
Yes.
Councilor Vogel,
Yes.
Councilor Wallace,
yes,
Councilor Zeid,
Yes.
Councilor Devlin,
yes,
Councilor Khan.
yes,
Excellent. Councilor Lane,
yes,
Councilor McCauley,
Yes.
Councilor Connell,
Yes.
Councilor Agaman.
Yes,
11-0, appointments approved unanimously.
thank you. Orders.
First order is a resubmittal of Order 178, which relates to the acts of 1987. And with it is the mayor's order, letter of non-support.
Motion to approve.
second,
There's second. Okay, discussion. Go ahead, Councilor Z.
Thank you, Mr. President. So, you know, this is not something we do very often, but what I'm asking for an approval on here is from the council, from my colleagues here, for us to make an effort here to override the mayor's veto. Letter of not support, I think, is another way of saying veto. So that's the intent here. And I just have a few comments that I'd like to make. First, I want to reiterate, you know, some of the discussion and some of the arguments we had over this not too long ago, that this is a change. The goal here is to make a positive change to how school budgets are set and to create an important check and balance. The idea is to create more collaboration and more discussion. I realize that some disagree that it would create that, but I do think it would. And to restore some of the power to the school committee on school budgets. Right now, effectively, they have a very surprisingly small voice in the budgets that are set, and this would create a different process, a better process, in my opinion. It would not, pardon me, allow city councilors to override the school committee in any way. In fact, the way that these acts of 1987 work is really the sort of the request to exceed the mayor's appropriation actually originates from the school committee. It does not allow the city council to exceed the tax levy. And, you know, this is something that actually has a pretty high bar in order to being needed to be effectuated, which is in order to have a higher budget, then you'd need basically both a majority of the school committee as well as and combined with a supermajority of the city council. I think the question I'm trying to ask you tonight, in so far as being one of the sponsors here, is, you know, is this the right policy for Newburyport? Does this make sense for us? And just a couple of weeks ago, not too long ago, we said yes, it does. In fact, the vote was 8-2 to 1 absent, 8 in favor, 2 opposed. in 2015, a city council, which I didn't sit on and others didn't sit on, also thought it was a good idea. And so we've also had through committee meetings and other communication support from a number of school committee members as well. I had really hoped sincerely that the mayor wouldn't veto this in the end, and that we would be able to find a harmony here and move forward, since this does, I think, create a better process. And I'd hope that the mayor would agree, but unfortunately, that is not the case. And so, really, I think that's really what I think we should be debating tonight. But I understand and recognize that some will question whether the city council has the power or authority to override the mayor's veto. And you know, I'm happy to debate that, although I don't think that should be the focus. The focus and should be, is this what's best for Newburyport? And to answer that question again, we just did that recently, and we've done that as a body in previous years. But I can certainly understand wanting to understand the details. So the acts of 1987, I'm sure everybody has read them, Chapter 329. They state clearly that, you know, that they can only be approved by a vote of the city council with approval by the mayor. This is not disputed. There are IGRs and other documents to the same effect. But with that in mind, you know, everything has to come in context together. And our city charter, which is also state law, by the way, a home rule charter, which we didn't have back in 1987 when this act was originally passed, also has some provisions in it. And the one that I'm bringing this to you under tonight is section 3-7, which clearly states how a veto can be overridden, or in other words, how the city council can use a 2/3 supermajority in place of the mayor's approval. And this is a fundamental check and balance, just like anything else. And you know, the irony here is that the acts of 1987 are designed to create a check and balance on the mayor. So I find it somewhat ironic that, you know, there'd be this argument that the city council can't override the mayor's veto. I understand that a similar argument or discussion was had in 2015, and the city solicitor did opine at that time as to his views, but at that time, no further push was made for a second vote or an override vote. That's what I'm doing now. I think those debates were had under different circumstances. There was specific money that was being discussed, and an agreement had been reached on it. Here, I'm just pushing for what I truly think is better process. I really hope that, you know, we'll get, you know, a supermajority to agree tonight. It's so interesting. I've learned, obviously, in my time, as we all have from our different experiences, but, you know, we're always debating and discussing where the line is of power between different branches here. But it's so interesting to me in the last month that a lot, you know, we've been basically arguing about what the city council can do within the city council. And it's sort of a bit ironic and a bit tough for me to accept that a lot of the attacks come sort of from within, that we don't have the power to cut things, that we don't have the power to override mayoral vetoes. These are some of our most fundamental, most important, most basic powers. So I believe very strongly that the charter gives us clear direction on how we can override a mayor's veto. It's germane tonight. Section 3-7 not only provides the process, it also provides the timeline. And that timeline stipulates that, you know, you have to deal with the veto within 30 days of receipt. The receipt of the so-called letter of non-support, which is a great euphemism for veto, was received on October 1st. And so that's why I'm not asking for you to send this to committee. I'm asking you for you to take a vote. So I really hope that, especially, you know, please, if you voted in support of this just a few short weeks ago, please don't change your vote. You know, we have the authority. This is our process. The charter states it. We're never going to be able to come to a conclusion on policing ourselves or trying to be lawyers against ourselves. That isn't our role, and it isn't really fair to us. But I've tried to outline the position I take on the city council's power, where it's derived from. And this is a good policy for Newburyport, and I think it's served other communities that have accepted it as well. And I look forward to the debate, and I ask you for your support. Thank you.
Councillor Vogel is next.
Thank you, Mr. President. If I may, through your chair, the councillor from Ward 1 spoke of euphemistically that it was a veto. Is there a veto on the table? Have we seen a veto of our efforts, or we just saw a letter of non-support? And is euphemistically speaking the same as a veto?
Well, I think the mayor has to act under the charter within a certain amount of time to sign legislation. So let's look at the charter. Again, this is just our opinion. The only we can go to court and get a declaratory relief. Let's see. If the mayor is section 3-7, if the mayor approves of the measure, the mayor shall sign it. If the mayor disapproves of the measure, the mayor shall return the measure with a specific reason or reasons for such disapproval attached to it in writing to the city council. So our charter actually doesn't even use the word veto. That's the phrasing it used. So I believe we do know that the mayor didn't sign it, and she did send us a letter back saying she didn't approve of it, and she did give reasons, as I recall. That's as much as we can establish.
If I may follow up.
Sure.
So where does that put us? I mean, that's as much as I can, to your words, that's as much as we can establish. Where are we? I mean, are we following process? Is this a veto?
Well, no, I'm sorry. Yeah, so we're following process. I think that the dispute is that back in 2015, when we passed this unanimously, we had the same city solicitor, Mark Rich. He wrote an opinion where he found an analogous language. It was a case that was referred by the Senate, I think, to the Supreme Judicial Court. And they said, tell us what this language means. And the language was similar to what's in the 1987 Act. So what the court did is they interpreted, he cited that decision. I don't have it at my fingertips. So the question is whether under the 1987 Act, the mayor has to affirmatively sign the legislation, to put it in our language, in our charter, in order for it to take effect. Mark Rich's opinion was that the mayor did have to affirmatively sign it, and that you could not override. That was his opinion 5 years ago, and he repeated it again this year, citing the same case. The problem is we don't have a case interpreting the specific act of 1987, and we also don't have an interpretation that in light of our charter. That's what I mean by that's as far as we can take it.
I'll yield. I see other hands.
Okay, let me go to Councillor Connell.
Yeah, Mr. President, I think that one part of our problem tonight is that the mayor did not submit the reasons for her rejection of this proposal, and therefore did not conform with the terms of the charter. And I'm wondering if we might not table this item and ask the mayor for some clarification of her reasons so that we can act on her rejection more fully informed at our next meeting. That would give us an opportunity to understand her reasons for rejecting it. And I'm certain that our discussion tonight will be conveyed to her, although she's not participating tonight, through her chief of staff, and perhaps come a little closer to some sort of discussion that I think a majority of us would like to have about the merits of this particular proposal.
Well, I just want to direct you to the packet. Again, I'm not trying to be argumentative, but my understanding is that she did give reasons. That's what I read. So in the packet, it's page 38 of part 1. So
look.
Yeah. Let's see. She speaks of increasing the budget over the past decade for schools. The development of the annual budget is a very detailed and complex process requiring months of work with input. I do not see any reason to alter this extensive process and the resultant final budget developed. The mayor is obligated by law, blah, blah, blah. So, I mean, I read those as reasons. I read those as
I didn't
reasons.
read them as such, but
Yeah.
unless there's something additional.
Well, maybe we can turn to Clerk Jones, because again, the
That
only other,
explains
the only other
process by which
veto,
we get to
yeah,
where
the
we
only
are.
other, yeah, the only
Thank
other
you.
non-approval I can remember in my 7 years, and you've been on longer, of course, Counselor, is
No.
is in 2015.
Yeah.
Yeah, I mean, I think it's sort of a case of first impression because of what you said, meaning chapter 3-7 of our charter was not in effect. Yeah, I think you're referring to the Gloucester case. I haven't read it in a long time. But I'm sitting here thinking, if this does pass, what does the clerk do? Is it law or is it not law? Do I go back to the city solicitor at that point? And I assume he'll give the same opinion?
Yeah,
Do
no,
say-
I think here's the issue as I see it. Again, not on the merits of whether to do it or not, but procedurally. If what the mayor sent us on October 1st does meet, it is a refusal, right? So that it didn't become law automatically, because she only has 10 days to act from the moment that the legislation is brought to her. So we got two choices. If this is not an actual refusal with reasons, then that means that the law was adopted because she failed to act within the 10 days. I don't think she's going to take that position.
Yeah, I mean, if you're asking my opinion, I would think.
Well, let me finish.
Okay, sorry.
The other choice is that she did indicate within the 10 days that she got the legislation, to wit, October 1st, by this letter, that she was not going to sign the legislation, and she gave her reasons. So then that gives us 30 days. Today's the 26th. So we only got 4 days left if we're going to override. We don't know that an override is actually going to work because our city solicitor thinks no. But the only way to decide that is a different section of the charter, 9 something or other, I think it's 9.4, where it says if there's a question of interpretation or powers or any of that stuff, you go to chapter 231A. So I think to answer the clerk's question, the clerk's got it. We got to go to court.
That's where I was headed. I mean, you're essentially just seeking a declaratory judgment. And
That's right. Yeah.
the question is, how do you get there? I mean, firstly, maybe, I think you did ask this. I think looking on the face of this letter of so-called non-support, there's probably sufficient reasons in there. There's a long paragraph with reasons why not. And then, so the interesting thing to me is that the council takes a vote. Let's assume it's 2/3, comes back to the clerk's office. What's the clerk do? Is it law or is it not law? So I asked the city solicitor. The city solicitor says, well, same opinion I always had, no. And so at what point am I authorized, is the council authorized, is to whomever authorized to go in to seek under 231A? So it's almost that's where I would be. I'd be probably coming back to the council saying, what do you want me to do?
Well, I'll tell you what, I mean, I think let's see if we'll have our debate. We'll see if we do in fact override
Right.
within our 30 days. If we do, then I would entertain a motion to direct the clerk to use chapter 231A. Because otherwise we're just wasting everyone's time.
Right, and and I'm left without a clear path. Thank you,
Right.
that would be good.
All right, let me keep going through the hit parade. So I have Councilor Khan who hasn't spoken yet.
Thank you, Council President. First of all, can you hear me? I've been having problems.
Yeah, you're a little
with
faint, so
Comcast
just
here.
speak up.
Okay, I will.
That's good.
Great, thank you. So this is obviously, I do not change my position on the acts of 1987. I am in support of this, and I was when I voted. However, I am not necessarily in support of this method to try to make this happen. And many of the reasons have to do, going back to my research when I did find this to be a compelling adoption for our city. And most of that, the reason I found it compelling was the fact that it seemed like a natural kind of checks and balances of these bodies of what we do in terms of someone going around setting the budget, someone working in terms of the school committee in looking at that budget, identifying needs, and then coming back, rounding out with the council, which actually does the ultimate approval. And for the acts of 1987, in terms of the city council, to see a need to increase the schools, it's in conjunction with an approval from the school committee, which to me is a great way of how you can make that work. This method of trying to, I guess what I would say is one of the things that I read when I looked at everything regarding this Chapter 329 Acts of 1987 was that there is this method of the city council also kind of signing on with the mayor to adopt it for the city. And in my review of looking at other communities, you know, this is really something eligible for cities, as I mentioned during our debate on this topic. And then in looking at the cities that did try to execute it or did try to implement it, Pittsfield is one example, as well as Fall River, and then Framingham. And in those examples, in one case, the city council didn't approve, so it died there. In another case, the city council did approve, but the mayor didn't sign on, so it did not go anywhere else. And they also have a similar provision that we're talking about now, meaning the city council could by 2/3 override that refusal, but they didn't elect to do that. And then finally in Framingham, where the council supported and so did the mayor. And then we have Newburyport, and I'm looking to see how we're going to look for other communities and if there's an opportunity to learn on how we can make something like this actually come to fruition. So what I was hoping to do as chair of the education committee, we do have the letter of non-support in committee, and that's going to be talked about on Monday. And I guess what I was hoping is with the school committee, because we didn't get to that level, it would have been nice if we did, but with the school committee to actually go through, first of all, understand what's in the Acts of 1987, which I think even given some of the emails we got from school committee members, I don't think they really understood. The school committee, the co-chair, his letter had a lot of things that showed that there really wasn't an understanding of how it worked. So for me, working with the school committee to actually have a response and come up with a list that we could then work with and have the mayor at that meeting. I was going to invite her to on Monday. And that way, then we could reintroduce this and we could kind of move forward with also having having the mayor or a future mayor supporting it and seeing how it could actually benefit the community. So I will not support this method of executing something that I think is going to be good for the city, but I guess at this point, just from what I'm hearing, I don't like going about it this way. Thank you.
Councilor Devlin is next.
Yeah, just as a preliminary issue, I with regard to the clerk's question, the case out of Gloucester gives us a good example of, or gives us a good road map of what's going to happen if we pass this. It then shifts the burden to the mayor's office. If they want to pursue this through Chapter 231, they can, or but that's exactly what happened in the Gloucester case. The city council actually did what they were supposed to do. They voted on something. It had a super majority number of votes. And then when the mayor vetoed it, they overrode the veto. And that put the ball in the mayor's court to say, and okay, either I agree and we can go on, or I'm going to take this to court. I would say too about that, this is not a similar case. Again, this is, first of all, the council is not in a good position to determine whether the things that they do are lawful or not. That's not how the system works. It's funny, we're having this conversation, 2 meetings in a row, but that's not how the legal system works. Our lawyer is giving an opinion, and frankly, it was a very brief opinion, and it cited one case, and that case is completely distinguishable from this case. That case was reviewing a override of the mayoral veto on something that was what they were doing was based on a constitutional amendment. It's sort of like they were having an argument over our Bill of Rights. So it's not another statute. It's a higher authority. It is a part of our Constitution, the Home Rule, petition and framework, and that's a very different review in the judicial process than that of the power under statute. So let me explain what they were doing in Gloucester. They were trying to petition to the state legislature to write a law specifically for Gloucester. So they prep the law, and then the legislature is not allowed to write municipal specific ordinance. So they have to write it for all the municipalities. If they're, it has to apply to all the municipalities unless it follows this home rule petition procedure. So the legislative power of the city asked under this constitutional amendment. So it's a part of the Mass Constitution, asked the legislature. So that's where that language that they're talking about is coming from. The highest authority in the state government is our Constitution. So they were asking the state House and Senate to pass legislation that they were sending to them. So it was backwards. It was different, and it was only applying to Gloucester. So the state Senate, when it got up to their committee, said, well, listen, they have the avenue of being able to go and ask the Supreme Judicial Court for a review and an opinion. That's not something that we do have. So they have the avenue to actually go get the answer, which we don't. Our avenue is one or the other side, who either the winner or the loser take, usually the side that ends up on the losing end, they either decide to let it sit or they take us to get a declaratory judgment out of the Superior Court. So this is distinguishable. So the city was asking the legislature to pass legislation for them specifically. That's different. What we're doing right now is we're acting on legislation that the House and Senate already passed as an aid to all municipalities. So there's a great distinction there. And you know, being one of the only two lawyers here, it is a significant legal distinction. But that's as far as I want to go, because again, in my role as counselor, I'm not here to decide, to go second guess a vote that we've already made, because whether it's legal or not. You know, my job is to decide, when I was actually the origins of this and my participation in this was from 2 years ago, or 2 budgets ago at least, when we had made some cuts. Some of us wanted it put towards the schools, and the superintendent, who had been sitting in the mayor's office, a highly, highly irregular thing to have the superintendent sit in the mayor's office for almost 4 hours, to come back out and tell us he didn't want the money. And so, you know, the reasons in the first veto or non-support were because the mayor stated, we always work out together, you know, that extra money can go to the schools. Well, that stopped happening. And that's, you know, it happened the first year that I was on the council, which I've mentioned before. And that was the best I've ever felt about a budget. Since then, it's been rancorous, and we've been sort of attacked when we've tried to make cuts. And last year, the cuts that we offered to the school, I felt were thrown back in our face. So at least that I'm talking about, when I say us, I'm talking about those of us who suggested it get put to the schools. So but again, we're not in a position, maybe 2 of us are in a better position to kind of know where the legislation would go. But if this went to court and for a declaratory judgment, we would have a much more significant legal briefing of the cases. And but I can just tell you, this case that was presented is not dispositive of this at all. There are serious distinct legal distinctions from an argument that could be made. And I'm just not going to do the resource. That's what I do all day. I'm not going to do the research to argue something that I can't even, I'm just one vote. I can't come up with the final decision. None of us can. It's our job to say, what do we think is right for the residents of the city of Newburyport? And we did that. We did that the last meeting, and or two meetings ago, and we passed this. And so I feel, once again, we're back into debating something that we've already debated. I call it debate redux. And what's happening is 5 years ago, this passed 11-0. I went back and looked at that video. There was no discussion about it. It passed 11-0. I don't know why people didn't try to override the veto, but they didn't. Now this one passed with what I would think is a veto overriding majority, 8-2 with 1 absent. But it sounds like people are changing their mind again, but this is the process. The process is not always that everybody agrees. The mayor, I would suggest that the reasoning that I don't want to do it this way is unsound. The mayor could have made that decision. She could have said, I don't want to do it this way. Let me go talk to the city councilors to see if we can reach some common ground. But she didn't. She rejected this. And so it's up to us, just like the city of Gloucester happened when it got rejected, it's up to us to stick to our guns, have institutional credibility, and do what we're supposed to do. So I wish there was another way around it. Honestly, if there was a way to get this in the committee without losing our 30 days, that is a concern to me. I wouldn't mind going into committee and delving into this further, but the problem is we're still going to come, we're not going to, lawyers can't give you the answer. Only courts can. And there's not a court case on point for this act. I will agree with the counsel from Ward 1. This is completely illogical for me to say that they gave us an act where we could take a small piece of the mayor's power and transfer it if there's overwhelming 2/3 and 2/3. So school committee plus our 2/3. So that's overwhelming support of the elected representatives in the city want to raise the budget, but they can't raise it more than 2.5. That's a high bar. I can't imagine the legislature, and this is what would happen in a court case. They would analyze what the legislative history was and what the intent of the legislature was. And it wasn't, they knew that a piece of the mayor's power was being, switched to somebody else. And so, they would never say, well, but you also have to get that person's agreement. It's an illogical reading of the statute, and courts don't do illogical. They do in this case. Just one more thing on the home rule petition. The reason the amendment, the constitutional amendments was it was specific because they were asking, because the thing that was being asked by the municipality was to make a law just subjecting that municipality's residents to it. So it was very specific to that municipality. They wanted to ensure the people who drafted that constitutional amendment just after World War II wanted to make sure that the population of that municipality was in support of this. So the 3 things they did in that it's in section, the footnote 4 of the case. The 3 things they did was, it's on a petition filed or approved by the voters of a city or town, or the mayor and city council, or other legislative body, or, sorry, Kate, I'm busy, or at the town meeting. They wanted to make sure, so it's either by ballot or by both branches that are elected in a city, or by town meeting, which is another way of getting town, resident input. And that's what the case goes into detail. That's what the explanation is that this amendment is focused on making sure the residents of that municipality, who's the only one that's going to be subjected to this, that they are in favor of this, overwhelmingly in favor, I think they use. That is not the case with the acts of 1987. So these are completely different. Don't get confused by legislation. It's our job, if there's a 2/3 majority, it's our job to stick up for our vote. And then, the mayor can either take us to court for declaratory, for declaratory, they're not taking us to court, go for a declaratory judgment where it will be briefed. It's not up to our city solicitor. If Clerk Jones went to the city solicitor, I actually don't think that's the appropriate method. He's opined. I don't agree with him, and he didn't do a very detailed brief on it. And so now it's up to us. This is what the resident, 8-2 to 1. This is what the residents want. 11-0 4 counselors on this council right now voted at one time for this. I urge you to support this. Let's do our job. It doesn't have to be personal. We're not insulting the mayor's office. We're doing something that happens across the country and across the world a lot. It's just the interplay between the legislation and the executive. Thank you.
Thank you. Councillor Tantar is next.
Sure. First of all, I'm in the Charter Review Committee. We ran across the Gloucester case because there was a part of the case that had to do with that section of how to change a charter. And I can't cite the law right now, but the language is very similar to this. It says you can change a charter with a 2/3 vote of the city council and the mayor's approval. Right. And I thought that was what cited. There's a similarity there in the language. As I recall, the Superior Court there said that mentioned intent of the legislature, that the legislature, because they used that particular language, I don't know how they came to this conclusion, indicated that you need both 2/3 vote and you needed the mayor to approve. And that was the intent. And now whether or not that's the intent of the legislature in the acts of 1987, I don't know. All right. I would agree with the at-large council, and that would have to be decided in the court. As far as the legal part of it is concerned, I think we need, if you want to do it, that's what you need to do. On the substance of it, I did try to do some research. The question I had, and I raised it last time, is whether or not the acts, acceptance of the acts of 1987 actually does result in an improved process, which would assist the city in allocating some of its funds to education. And actually, so what you'd expect to see is that multilinear analysis, because there are other factors, you'd expect to see that communities that accepted this and used it had a process that resulted in better schools or more money for the schools. And I couldn't find anything, and the sponsors didn't offer any evidence in that way. So I raised it. There could be unintended consequences from its accepted that would actually allow to more infighting between in the budget process between schools and other departments. And that's my concern. Not having any evidence, all right, that this helps, I couldn't support it this time around. So I'm just explaining my vote again.
Thank you, Councillor. Now, does anyone wish to speak who hasn't spoken yet? Not at this time. Let's loop back to removing Councillor Zeid and then Councillor Khan.
Yes, thank you. I apologize since I'm at the bottom of the list here. I got to rewind a little bit just to respond to a couple of comments. So first one is, to the at-large councillor who spoke first, I'll be honest, it never really occurred to me that this didn't count as a veto. So that's an interesting question. If that's the argument, then this is accepted. The language is pretty plain. If the mayor doesn't act, and if this doesn't count as an act, as the president stated in his opinion, and I certainly agree, then this is the law. Then it's done. Actually, that the acts of 1987 are now the rule in the city of Newburyport. So I obviously didn't read it that way, or I wouldn't have put it back into the packet with my co-sponsor for another vote. So I don't know what to say about that one. That's number one I wanted to respond to. Number two is I wanted to respond to the clerk's comments. I guess I don't understand the comment. So if the council passes this with a supermajority or more than supermajority, why is the clerk presupposing a conflict? That's not our job to raise a conflict. And since when do we run to the city solicitor every time we pass something and say, hey, are you okay with this? I didn't understand that line. In my opinion, and I think the other at-large councillor spoke to this, if this passes, then we follow the same process we have in the charter, which is that if it passes by a 2/3 majority, then it is considered the law of the land here in Newburyport. And if anybody takes exception with that, whether that's the mayor or someone else, they have process available to them to challenge that. And in our case, that's largely to go to court and to try and get declaratory relief, as it's called. I don't understand why we would rechange the process on this. So the city solicitor thinks that we're wrong. Okay, great. Every week I lose a number of votes, and many people think I'm wrong. Many people think I'm right. Life has to go on. I'm not sure that the city solicitor's opinion is any more weighty than anybody else. So respectfully, I think that that's the incorrect process. If this passes, then it's the law of the land, and unless somebody wants to challenge it. So I don't know why we would presuppose a conflict, or why the clerk would feel like he's in any difficult position to deal with this. It's just like any other vote we take on the council. Anybody can take exception to votes. In fact, we've had residents take exception with votes that we've taken on some contentious issues, and some have led to other processes and ballot questions and all sorts of things none of us want to relive tonight. So that always happens. There's always that potential. The third thing I wanted to address in that same concept is, this brings up a long-standing point, a long-standing discussion, which is, who is the city, and who do these people work for? Who does the city solicitor work for? So, we debated whether the city council needs to have its own attorney. If a 8-3 majority of this council agrees, who does the city solicitor represent in that case? Is that representing the interests and the desires of the administration, or that of the council? If we did end up in needing declaratory relief, the mayor said, well, I'm not happy with this, I'm going to challenge it, then the city council, in my opinion, would have to defend itself, and in that case, the city is not one person or one branch, it's a combination. And so that's a big issue for me, and a big problem, and one of the reasons that having the city council have its own money for its own attorney is so crucial, because when we're in conflict with one another, we can't simply look to the for example, anyways, I'll just leave it at that. And then the final one is, I just want to address another comment made by a different at-large councillor about, I don't like this process, or I don't support the method. I understand the impulse. It's kind of frustrating to have to go through a veto override and all that stuff. But, as a sponsor, I just want to make clear to anybody who's listening, I'm not doing anything wrong, neither myself nor the co-sponsor. This is the process laid out by the charter. And there seems to be some sort of underlying implication there that somebody's doing something wrong, or this isn't the way to do it. This is the process. And the concept that we're going to go back to committee and convince the mayor, who has twice vetoed this over a period of 5 years, and go back to the table and figure out a way. We just have an impasse, and that's okay. I respect the mayor's letter. I respect the reason she provided, and I certainly, understand how a mayor could come to that conclusion, any mayor. But this is the process, and the question is, do you agree or disagree, and what's best for the city? And that's the debate that we're having tonight. And I appreciate the at-large councilor's point on, okay, here's why I don't support it. Obviously, I don't agree, but that's the right debate to be having. And I just no one can say how something's gonna exactly work in a certain city, but I think here in Newburyport, this would make an immense difference in a positive direction for the conversation that we have, engaging school committee members in a real way in the budget discussion, in a way that they're not. And I think the president of the council opined well on this last time about the history and sort of how the school committee's power has been diminished on the budget, particularly through other earlier, perhaps unrelated proceedings, but that this is actually a restoration really of the school committee's power and prowess on the budget, more so than it is the council's. We'd still be in a position where we have to work with the school committee, and that's a good thing. And we have to get their approval, and we have to get their majority vote in support of an override. And then on top of that, look at how hard it is here tonight to get 8 out of 11 on anything, on zoning, on this, on whatever we might be the issues of the day. So I can't see how that conversation leads to more infighting, as was stated. I think this is just a whole new world in terms of collaboration and saying, what do you really need? And if you really need it, then we have that conversation. And if 4 out of 7 plus 8 out of 11 agree, that's pretty overwhelming. And so that's why I'm asking you to support it. So I apologize again for having to kind of go backwards to rewind the tape a little bit to respond, but I did want to make those points.
Thank you. Well, Councillor Shan has not spoken yet, so under the rules, she would be next unless she wants to yield to Councillor Khan.
I'll yield to Councillor Khan.
Okay, Councillor Khan.
Great, thank you. Thank you, Counselor Shand. I guess I'm going to be brief, but there's really three aspects though, to just kind of go back to why I guess I'm having misgivings with this action. The first one is, again, when I researched the acts of 1987, when we actually voted on it, my understanding at that time, and it's not changed, is that it would be, it needs a 2/3 approval by the city council, and then it needs to be signed off by the mayor. I had no confusion on that. That was pretty clear to me. And part of it is, you know, there was an informational guideline release that accompanied. And for those of you who don't know, the IGRs come in combination with some of these types of Massachusetts general law options that cities could adopt. And in the IGR for Chapter 329, the Acts of 1987, there's an underlined portion, and it says Chapter 329 will only be effective if it is accepted by the council with the approval of the mayor or of the city manager in cities with a Plan D or E form of government. So for me, at the time of our approval, that was one of the reasons I thought, well, this works well. And again, I go back to Framingham, where the council supported it and you voted for it by 2/3 and the mayor signed it. So that's really a key aspect of why, from a procedural perspective, what I see, like, I think what we're trying to do is we don't like that. And so what we want to instead do is say, let's let it go to courts and let them see if that statement is correct. And if we're going to do that for every single thing brought before us, that's kind of not, to me, that's not the procedures that I want to inflict, because partly, and I always wonder, you know, how much does that cost the city to always have to take something and challenge it in the courts? What kind of example does that kind of put us in? So that's really one of the key objections that I have to what we're doing here. And again, the kind of actions I was outlining before is ways that I see that we could get that signature of the mayor and have the approval of the city council together. But the way to do that is to really maybe delve in a little bit more and explain the benefits, have that conversation with the school committee, which we really haven't yet. So that's kind of, I just wanted to clarify my position on that. That's a big one to me. Thank you.
Counselor Shand.
So a couple of questions. So, I mean, I would have voted in favor the last time had I been here. My questions are about the declaratory judgment. I mean, it does feel like we are going to court against ourselves here. I'm just wondering what is to gain there? And I appreciate, you know, everyone saying that we'll have the ability to go and increase the budget for the schools if we don't agree next year. It just feels like we're just relitigating the whole budget process all over again at this time. I'm just sort of wondering, why would we go down that path? Because I do see the same comments that the counselor at large mentioned. You know, Chapter 329 will only be effective if it is accepted by the council with the approval of the mayor. I mean, why wouldn't we want to send this to the education committee so that conversation could be had next week? Are we under a timeline here? So anyone can.
That was my point. Again, under our charter, there's no question, because it says within 10 days, the mayor has two choices. Either she approves by signing, they use signing and approving kind of interchangeably, or she doesn't. If she doesn't do that within 10 days, it becomes law, unless she gives reasons and decides not to approve or to disapprove. And the problem is, in our charter, we can't look at it again. Quote, the city council shall enter the objections of the mayor in its records, and not sooner than 7 days. So that would have been October 8th, nor later than 30 days from the date of its return to the city council, may again consider the same measure. And let me go on again, just giving you the words verbatim. And this is the problem, and I'll explain declaratory relief. If the city council, notwithstanding the disapproval by the mayor, shall again pass the ordinance or vote by a 2/3 vote of this full council, it shall then be deemed in force, notwithstanding the failure of the mayor to approve it. So they use both disapprove and failure to approve the same way. if the mayor has neither signed a measure nor returned it to the city council within 10 days, it shall be deemed approved and enforced. So again, we know those are the rules. The problem is we have a statute which says approve, and it's never been interpreted to tell us whether that means the mayor must affirmatively approve, or whether, just as in our charter and in our code before that, the mayor is supposed to either approve or disapprove, but we can always override. That's the question. So then we get to declaratory relief. It's not suing yourself. It's not like, you know, we're suing the city of Newburyport on behalf of the city of Newburyport for doing something illegal. That's not it. The whole point of declaratory relief, which they didn't have to cite in our charter, by the way, because it already exists under chapter 231A, but they made pains to say, look, if you guys in government, all of you, can't figure out what to do, you always can go to 231. So let me read you that. It's section 9-14. The procedures made available in chapter 231A of the general laws, and that's the declaratory relief statute, may be used to determine the rights, duties, status, or other legal relations arising under this charter. It doesn't say every time you pass a law, you can go get declaratory relief. It says when you have a question about rights, duties, status, or other legal relations, which is what this is, including any question of construction, meaning what do words mean, or validity, which may be involved in such determination. So there it is on a platter, and we've never used it, at least in my time, so 7 years in. It's not expensive. There's no discovery. It's the only way you're going to solve it. I was suggesting that if we do override tonight, then we would have an active controversy. Somebody could bring a declaratory action. If you read chapter 231A, anyone who has rights that are at issue is an indispensable party. So we would end up, arguing our side of it anyway. The situation arises all the time in a city attorney situation where one officer and another officer disagree. So they would have to recuse themselves. We would get two different lawyers, and they'd argue it, or we'd argue it ourselves, or whatever. But again, it's not like a slip and fall case. It's just, what do these words mean? And in fact, I would think the court would be interested in resolving it, because we're asking them to interpret a statute that has statewide implications. So I don't think it's really a bad idea. The question is whether you want to do it. And I think what is not open to question is, if you don't do something to override within 30 days, it's dead. It's dead. There's no active controversy for the court to take up. We'd have to start all over again. And it's unclear also from our charter when you can start all over again, because it says you have a deadline to act within 30 days. Well, if we could just introduce it again in the same session, when would it ever end? We just keep introducing it every 2 weeks. So I guess the question is, do you want this thing or don't you? And then yeah, we have to go to a court. There's no off the shelf answer. That's the way I see it.
Okay. Thank you.
I've lost who's next. So let's see. Councillor Devlin is next.
Yeah, just so you're actually missing an option, Council President, which is there are a couple options if we voted to override the veto or lack of support. The mayor actually could come back and say, okay, you guys really mean this. You're serious about it. Okay, I'm okay with it. It puts the ball in her court. She could say, okay, let's talk about this. Maybe I won't take this to a declaratory judgment. Let me hear what you all feel on this. The school committee members that I've spoken to are in support of this. I'm pretty sure we got an email from them that said from individual school committee members that were in support of this before the hearing. So I'm not sure why we have to bring it back to them. It's the mayor who's not supporting it. She is not the school committee. She is the chair of the school committee, but she's one of the votes on the school committee. So that's the first thing. The second thing, everything we do requires the approval of the mayor. The mayor signs off on that's why we have that charter provision. So it's not, I think maybe the council at large is saying that her vote was relying on the fact that she thought the mayor also had to approve for this to go into effect. And that's a valid point. But for me, this is everything we do requires approval of the mayor. It's the argument that we're talking about is, what does that mean in this statute? Does it mean the same thing as it did when we're talking about a constitutional amendment in the home rule petition, where we're asking, the legislature to do something just for our community that subjects our residents to something different? Or does it mean the same thing now when we are taking advantage of something that the legislation passed for our benefit to help, I think, bring more elected officials on limited circumstances into the school debate budget? Most of our arguments in the past, 5 years with the budget was around the school budget, and we have the ability to say no to it but not to raise it or frankly, even to have any meaningful impact on getting it increased. So I would just say, let's not confuse. The IGR has no precedential or probative value. It's frankly, it's repeating those underlying words. It's repeating what's in the statute. It's not interpreting what's in the statute, and they have no power or authority to interpret what's in a statute. So again, I think we're missing one option. If we vote and override this, I think we are saying, hear us. We're serious about this. And there is a potential that this nothing happens, because the other side has to act. And are they going to act? If the ball's in their court, are they going to go and seek a declaratory judgment? If they do, that is part of the process. That's why it's built into our charter. I think this is so important. And I think bringing more elected voices into the process on this limited basis in a 2/3 majority and at the direction of the school committee, there's a lot of things have to happen for this to occur. So it's extraordinary circumstances. I think the residents want it. I think it's in the best interest of the residents. I think that's why we voted 8-2 to 1. And I think we should do it again. And then we can still have discussions with them. If the mayor's office is going to be reasonable, we can still have discussions with them. It doesn't have to. We could 2 weeks from now, we could reconsider if we had to, but it gives it time it's putting it into somebody else's court. I didn't ask her to veto it. In fact, Councilor Zeid, the other sponsor, was he asked, please support this. Please don't deny it. And here we are. Thank you.
Okay. I think it's Councilor Zeid's turn again. No, is it Councilor Tantar's turn?
I think it's Councilor Zeid, but
Yeah, Councilor Zeid.
Yeah, thank you. I just wanted to respond to one point, as far as, sort of what is the message we're sending? The message we're sending is we have a process. We try and come to agreement. If we have a conflict, we resolve the conflict by the rules that we all agreed to have, which is the charter. We have vetoes, we have veto overrides. We even have a way to continue the discussion if we want to. And there's nothing, I don't understand the argument about money, and it's such an interesting thing. I'm probably typically associated as a counselor doesn't want to spend money or is more frugal or whatever the word you want to use is, but what's wrong with spending money on process? I mean, it's sort of like this irony of cutting the city solicitor budget as though what we do every 2 weeks doesn't have to do with the law. And it's crazy that at some point in our careers, we may have to spend money on declaratory relief or litigation to protect resident interests, to resolve disputes between the administration or the executive branch and the legislative branch. I mean, that's just normal doing business. I don't get that as though we've released something new. And the last thing I wanted to say was just I'm not relitigating the budget personally. I put this in April. We put this in April. I mean, it's been sitting, it sat for several months in committee. To be quite blunt, I mean, the mayor was pretty clear from early on, she didn't like it and she wasn't going to support it. And again, that's her prerogative and she has her reasons and she makes her case. And that's essentially what we're hearing tonight. But, you know, I didn't bring this in, or we didn't bring this in, myself and the co-sponsor, like 2 weeks ago after a budget vote and say, yeah, well, you know, we're not happy about this. Can we have a different process now? It's been since April, and again, it was deliberated by the council in 2015. So just a little bit of leeway there would be appreciated. It's not a response to something. This was put in well in advance months ago.
Now, Councillor Tantar.
Oops, thank you. I have a simple point to make. I just wanted to note section 1.4 powers of the city of the charter. And this is relevant in other places, subject only to express limitations on the exercise of any power or function by a municipal government in the Constitution or general laws. So, subject to express limitations by a municipal government in the Constitution or general laws. So, well, I agree with the councillor at large. I thought the language in the acts of 1987 was pretty explicit, that it required 2/3 vote of the council, and in addition, the mayor's approval. We have an agreement within the council as to the meaning of the acts of 1987. And so if we think this, I think I'm agreeing with the other at-large council, that's only going to be decided in the court, it seems to me.
I don't mean to prolong the debate, but it does say it's not actually general law. That's one problem. It says the adoption was not put in the general law or the Constitution. But I hear what you're saying about the express limitation. But just so you know, it's not a general law.
What, the acts of 1987 are not a general law?
No, the general laws are the MGL. So the general law would be the codified one.
Mm-hmm.
And the codified, and that's part of the problem is if you just read the codified law, it doesn't mention that it has to be adopted, but it was in the acts when they adopted it in 1987. And they didn't put it in the general law. God knows why. Usually they would. All right. Anything else? Anything else? Yes, Councillor Shan.
Sorry, can you explain that one more time? They didn't put it in the general law. They left it.
So the general law that we look at for budget, I have too many numbers ahead. Charlie, Councillor Tantar, which is the number for the general law? Which chapter is it again?
This is chapter 44, section 32.
Right. If you read,
you owe me a Coke, Councillor.
Yeah. So 4432, that is the general laws. So if you Google it, even that's what they mean, and it's called the MGL. If it's an annotated one, they call it the MGLA. But it's the same thing. And in that section 32, they have this whole bit about the 2/3 supermajority so long as the school committee says it's okay increasing the budget. But it doesn't say anything about that this is a local option, that you have to adopt it. But then if you go back to the acts of 1987, when the legislature came up with this language, it does say that it has to be adopted by the city council with the approval of the mayor, unless you're a Form D government or something like that. That's not the general law. And then when they put it in the general law, they didn't put that in. It's not in the general law. So you have to read the original act of 1987, but it didn't make it into the general law. That's all I'm saying. I'm not saying it's not clear or is clear. I'll say again, that's what courts are for.
Yeah, Mr. President, you made it much clearer.
Okay. All right, why don't we do a roll call?
Okay, the roll call on the motion to approve order 178. I know Councilor Zeid moved. Who was the second, just for clarity?
Joe, sorry, me.
Thank you.
Oh, I'm talking about myself in the third person.
Here we go. Councilor Shan.
No.
Councilor Tantar.
No.
That's a no. Councilor Vogel.
No.
Councilor Wallace.
Yes.
Councilor Zeid,
Yes.
Councilor Devlin,
Yes.
Councilor Khan,
No.
Councilor Lane,
Yes.
Councilor McCauley,
Yes.
Councilor Connell,
Yes.
Councilor Agaman.
Yes.
1, 2, 3, 4, 5, 6, 7, yes, needing 8. Motion fails unless I missed something.
No, that's the way I counted it too. Back to wherever we were.
Well, I mean, we would be moving on to the next order, I believe.
Yeah, we're in regular, order 218.
Correct, which is the city council approves the mayor's fiscal supplemental budget in the amount of $18,000, Essex North Shore Tech School. As submitted, Councilor Tontar.
Motion to refer to Budget and Finance.
Second.
Discussion. I have a question.
Mhm.
Didn't we already, I thought we already did this. We didn't do it?
No, we did a receive and file on the communication. And at that time, which was the last meeting, I noted that we would need a supplemental budget request. So all we didn't have a supplemental budget.
I got it. We just had the
All we had
letter.
was the communication.
All right, I apologize. I didn't, that went over my head. Okay, any further discussion on referring this to budget and finance? Seeing none, all those in favor say aye.
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 Any opposed? Okay, that's it for orders, right?
Correct.
Ordinances.
It's the second reading of ordinance 50, which is the ordinance with respect to driveway openings, notice of work involved in sidewalks, etc. Goes on for a number of pages. It is submitted jointly by Councilors Agaman and Wallace.
Well, I'll make it. She's muted.
Motion to approve.
A motion to approve.
Oh. Second.
Okay, so it's a motion to approve on second reading by Councilor Tontar, seconded by Councilor Wallace. Any discussion?
I believe it was Councilor Connell who moved to approve.
Oh, I beg your pardon.
We both did simultaneously. Your pick.
All right. C comes before T, so we'll go with Connell. Any discussion? No. Roll call.
Roll call for the second reading, ordinance number 50. Councilor Shan,
Yes.
Councilor Tontar,
Yes.
Councilor Vogel,
Yes.
Councilor Wallace,
Yes.
Councilor Zeid, Councilor Zeid,
Yes.
thank you. Councilor Devlin,
Yes.
Councilor Khan,
Yes.
Councilor Lane,
Yes.
Councilor McCauley,
Yes.
Councilor Connell,
Yes.
Councilor Agaman.
Yes.
Motion passes. Second reading goes.
Thank you. Next item, emergency preamble, it looks like.
It is. It's an emergency preamble. Which reads,
Before you read that, just to save time, is this the second time we've amended this? I thought.
third, with second amendment, third time we've seen the ordinance.
So what is the current law? I couldn't tell.
Current law, I believe, expires November 1st. Councilor Zeid would confirm that, I think. And
Yeah,
this,
October 31st to be more accurate.
Okay, got it, because I wasn't in the packet. All right, go ahead.
emergency preamble, emergency exists due to COVID-19. Therefore, the city council hereby affirmatively declares the emergency exists in order that ordinance 64 be adopted at its first introduction to the council, jointly submitted Councilors Zeid and Devlin.
Motion to approve.
Second.
Discussion, Councilor Zeid.
On the emergency, it expires October 31st. And so I was asking the council to take it up tonight in order so that we don't have a lag time in between. And I can speak more to the merits during the ordinance itself if you'd like.
Further discussion, questions? Roll call.
Roll call on the emergency preamble. Councilor Shan,
Yes.
Councilor Tontar,
Yes.
Councilor Vogel,
Yes.
Councilor Wallace,
Yes.
Councilor Zeid,
Yes.
Councilor Devlin,
Yes.
Councilor Khan,
Yes.
Councilor Lane,
Yes.
Councilor McCauley,
Yes.
Councilor Connell,
Yes.
Councilor Agaman.
Yes.
That leads us to the ordinance itself, ordinance 64, which I think I wouldn't misspeak if I could say the only pertinent part changing is the date on the second page to April 30th, 2021. Again, it's jointly submitted, Councilor Zeid and Devlin.
Motion, an omnibus motion to one, waive the rules to allow for passage of an ordinance in one reading, and second, to approve this, since it is an ordinance. Just do them
Second.
together. And I'll speak to
Okay,
it.
any discussion on that? We'll need a 2/3 supermajority. Councilor Z.
Sure, just briefly.
The point of order, Mr. President, did we hear a second?
Yes.
Councilor
Council-
Dutar. So the clerk already mentioned it, but the only change is extending this from October 31st to April 30th. The only thing I want to add to it is I attended the Parks Commission meeting about 10 days ago. So that the April 30th was actually their recommendation. So when the request was brought forward by some of the folks taking advantage of this offering, they just asked for more time, and we discussed on the Parks Commission, do you want to do December 31st? Do you want to go out to the spring? And in the end, I told them I'd do whatever they wanted to as an envoy to the council, and it was their suggestion and their unanimous approval on April 30th, 2021. Just so you know that that's where the date came from. It has been meeting some success, and obviously nobody knows if we'll be snowed in all winter, but this can offer some continued relief through basically through the winter when parks use is fairly low comparatively anyways. So I'm asking for your support.
Thank you. Anyone else? Okay, roll call.
Councilor Shan,
Yes.
Councilor Tantar. Councilor
Muted.
Tantar.
Yes.
Okay, Councilor Vogel,
Yes,
Councilor Wallace,
Yes.
Councilor Zeid,
Yes.
Councilor Devlin,
Yes.
Councilor Khan,
Yes.
Councilor Lane,
Yes.
Councilor McCauley,
yes,
Councilor Connell,
Yes.
Councilor Eigenman.
Yes,
Motion passes, ordinance enacted.
thank you. On to committee items. Ad hoc economic development, we have not met, but I do finally have a piece of news. There's a new grant that was made available from the state to the tune of 50 million statewide. So everyone has to scramble and fight over the scraps. I forwarded the information to the two sectors of industry that I was assigned to, but I'll forward it in case any counselors didn't get it already from Chief Matt Coogan. I'll send it again. Committee on Waterfront and Committee on the Whole. I think it's just ad hoc committee on the waterfront at this point. But in any case, we are finally meeting on the on Thursday, and a draft request for proposals has been put out by Planning Director Port, and we'll be talking about that text. If anybody, it should be posted and available and all over the place. But if anybody needs a copy, doesn't have it, let me know. Budget and finance.
Wait a minute. Motion to remove order 217 from committee.
second,
Go ahead.
We have to vote to remove it from committee.
All those in favor?
aye,
Aye.
Aye.
Any opposed? Okay, it's out.
Motion to approve.
second,
So the committee met today at 7 o'clock, right before the council meeting. This is acceptance of a grant of $7,002.50 from the Center for Technology and Civic Life. The purpose of the grant is to assist the city in holding a safe and accurate election. We met with the registrar clerk in the committee. He indicated that there was roughly $22,000 in expenses related to the extraordinary circumstance of the election this year over what we had budgeted. The grant for $7,000 has a number of possible uses according to the grant. including election department real estate costs associated with satellite election department offices, polling place rental, cleaning expenses, temporary staffing, election administration equipment. And the clerk registrar indicated a number of those categories, and especially temporary assistance. So the city certainly could use the $7,000. It was also noted by the finance director that we could tap into CARES funds as well, grant funds as well for this. And of course, we could, do a transfer from the general fund as well. The vote in committee was 2 in favor, 1 opposed to accept the grant. Incidentally, on the grant, there are essentially no real strings attached other than that you spend it for the purposes you said you would, and that you report to them.
Thank you.
All I have to say.
Thank you. Councillor Zeid.
I'm going to dissent on the vote, and the reason for it is, well, first thing is, let me just state that I did ask in committee if the election would be run the same way with or without this money, and the answer was an unequivocal yes. So whether this money is accepted or not, the election is not going to change in terms of what the clerk is doing to facilitate that election. Everything that needs to get done will get done. And further, if there are excess costs, my understanding is that, per the finance director, they would look towards the COVID money first, which is federal money filtered through the state. So it's governmental money is my understanding for that. And the reason I mention that is that I think everybody wants to do everything we can to have, the best, cleanest possible elections we have. There's a lot of talk over the years about money and elections and money in politics. And I don't know why you'd invite a third party in, no matter how good their intentions may seem, no matter how clean their paperwork. This is our obligation to fund elections and to fund them fully. And I don't have any reason to believe they wouldn't be funded fully. And I think this sets a bad precedent for inviting outside money in. This is from Facebook and Google. You may love them, you may hate them. It doesn't really matter. The point is we don't need this external third-party money, especially for that $7,000. This is our responsibility to fund it. And if more money is needed, then go to the COVID money first. But I'll say it here tonight: if a transfer was needed from free cash, sure, to support the elections, absolutely. Thank you.
Councillor Connell.
Yes, I appreciate Ward 1 Councillor's comments, but I want some clarification from the chairman of Budget and Finance. Again, I thought I heard you say there were no strings attached to this. Is that correct?
Chair Tantar.
Yes, I mean that when we applied for the grant, the city specified what it would be used for.
So we defined the purposes.
We defined, I mean, well, of course, as in any grant, the grant had specified what it could be applied for, but it was fairly broad, and we itemized some specific areas that I cited earlier. Other than that, it can't be used to replace funds already appropriated that would otherwise be available. Say they said, for salaries. And other than that, the only requirement is that we report.
Thank you. So therefore, it is to be used to supplement, not supplant, the expenditures that we have already appropriated. And I see absolutely no reason why we shouldn't accept this then. It seems to me a reasonable opportunity for us to obtain funds for the purposes of running free and fair elections, which are obviously extremely important, and that we should accept it gratefully and move on to the next source of funding if we need additional funds because of the imposition of the COVID pandemic on the resources of the clerk. Thank you.
Thank you. Do other councillors who haven't spoken yet wish to speak? Seeing none, back to Councillor Tantar.
Yeah, just the council from Ward 1 indicated this was from Google. It's not directly from Google. It's from a 501c3, a not-for-profit that is a center for technology and civic life. they do get significant funding from Mr. Zuckerberg and the family, but they technically are independent. They, as a 501c3, I looked at some of the not-for-profit rating agencies. They have 100% ratings across the board. I did notice that as for accounting and management services, they do use Markham, so they do ask Markham, and they. I mean, I don't think you have to be. I'm not concerned that this would result in any undue influence in any way, manner, shape, or form on how we run our election, other than to assure that it's done according to our standards.
Thank you. Councillor Khan hasn't spoken yet.
Yes, thank you, Council President. I will be supporting this. I did spend some time researching the Center for Tech and Civic Life to look at their mission. I mean, I could definitely see how, I could see some of the reasons for the concerns, because if you do look at the big funding and where the money is coming, it's very transparent in terms of what are the sources and who are the big donors for this money. But there are also several articles about it and the act of what's happening in terms of this money being available, knowing that also with COVID situations going on and the challenges that are being faced by a lot of these governments, local governments, in running an election. And so one of the articles that just actually came out today is the number of election offices across the country that are trying to apply and get this money. And so for me, I am happy that we got something. Beverly got 16,000. You could see a list of other Massachusetts cities that have taken the grant money. And I just don't see why we would turn away something like this that could definitely help us and help our offices out. So I will be supporting. Thank you.
Thank you. Any other councilors? Councillor Zeid had his hand up, but he's taken it down. So I'm going to assume we're all set. Okay, all those in favor say aye.
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 All those opposed?
No.
No, I got one no.
No.
Okay. 10 to 1. What's next?
I'm done, Mr. President. Thank you.
Thank you. Education.
Yes, thank you, Council President. I'll be brief. Our next meeting will be on actually the day before elections at the Senior Center. So I probably should check that venue, but we typically meet before the school committee's business meeting. So I will check with the clerk since that is one of the locations for the election. So I'm not sure where the school committee is meeting. So I'll let people know. But the agenda item is the letter of non-support, and we'll be talking with that. And I am going to invite the mayor to that meeting as well. And that's what we have, and I'll be sure to report out after that meeting. So thank you.
Thank you. General government has nothing to report. Licenses and permits.
Nothing to report. Am I unmuted? Nothing to report.
Yeah, no, we can hear you, or we can hear your thoughts. Neighborhood and city service.
Nothing to report.
Planning and development.
Sure. Motion to receive and file appointment 187.
Second.
So
Go ahead.
discussion. So given that the appointee is no longer employed by the city of Newburyport, we decided to receive and file the appointment of Mr. Armstrong as the building commissioner.
Any further discussion, receiving and filing? Seeing none, all those in favor say aye.
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 All those opposed? It's received and filed unanimously. Next.
Thank you. So next, order 211, preservation restriction for 272 High Street, the Kimball Widmer Second Trust. Motion to approve.
Second.
Discussion.
So we've had two meetings. The first meeting we had Mr. Peacock, who is the representative for New England Historic Preservation, who is the one that talked about the preservation that Mr. Widmer did on 272 High Street. What was not included in the original PR that we got in our packet were the pictures, which in this last meeting, we were provided the pictures. And I think if you take the time to look at it, you'll appreciate how much effort Mr. Widmer did in restoring this home. It is a gem, as was discussed with the Historic Commission, Vice Chair Pecknick and the Chair Richards both commented on it. So we're lucky to have this. The committee voted 3-0 to approve the preservation restriction.
Thank you, Councillor Connell.
I'll try to be very brief because this is just a point of interest. As I read through the restrictions and certainly plan to vote in favor of this, there was one that kind of provoked some thought, and that was the fact that an insulating cap can be installed or replaced, but nothing in the walls, which would make the building more energy efficient. How is that in the best interests of preserving an historic structure? And if there's someone at the table tonight who can explain that to me, I'm all ears.
Well, I can't explain that one. I do believe Mr. Peacock actually is in the attendees list. If you'd like to listen to Mr. Peacock speak.
I would.
Yes, I'll recognize Mr. Peacock. Mr. Peacock, can you hear us?
Hi, can you hear me?
Yes, indeed. Go ahead.
Thank you, Council President Eggerman. To answer your question, Councilor Connell, that is because it's standard language across all of our preservation restrictions. It's because you cannot insulate the sidewalls of historic property properly without either removing all of the exterior cladding or all of the interior plaster. Doing so would create moisture issues through the moisture migration of, during seasonal moisture migration. Essentially, you would need to put a vapor barrier. And the only way to do that would be to either remove the protected plaster on the inside or all of the cladding on the outside. So it's standard language across all of our restrictions. We have allowed insulation in places such as, say, an unfinished attic or a space that isn't protected where you are able to actually install that vapor barrier. So we do have the ability in that case. However, in this house, not all of those spaces are already finished. So I hope that answers your question, but I can elaborate further if you'd like.
That answers my question. I'm not sure I agree with the response, but thank you for the response. I appreciate it.
Thank you. Back to the council, Councillor Tantar.
Yeah, thank you. Just a personal note. Well, before I was on the council, because I own one of these ancient houses in Newburyport, I had occasion to visit Mr. Widmer's house, and he was so gracious. And I went through the whole house. He explained that the history of that house is fascinating, and just his commitment to preserving that house goes well on a personal level, went well beyond anything I certainly was capable of, but most occasions. I mean, he's really someone who should be celebrated for his commitment to the structure. And I just want to note that.
Thank you.
Oh, greatly agree, Councillor.
Further comment. This is real property, so let's just do a roll call.
Motion to approve Order 211. Councillor Shan.
Yes.
Councillor Tantar.
Yes.
Councillor Vogel.
Yes.
Councillor Wallace.
Yes.
Councillor Zeid.
Yes.
Councillor Devlin.
Yes.
Councillor Khan.
Yes.
Councillor Lane.
Yes.
Councillor McCauley.
Yes.
Councillor Connell.
Yes.
Councillor Eigenman.
Yes.
Motion passes unanimously.
Great. On to the next item.
Order 215, preservation restriction on the Central Congregational Church. Motion approved.
Seconded by Councillor McCauley. Discussion.
So we had Central Congregational Church, specifically Amantha Moore, come and speak to the preservation restriction that has been going on for some time. We did finally receive it. It had been reviewed by the Newburyport Historic Commission. I think a few updates were made based off of input after they saw some errors that Mass Historic missed. Specifically on page 3 of the preservation restriction, there were some comments made about the windows that have been replaced in the last few years. Those are now part of this baseline preservation restriction. So after that conversation, we did vote to approve the preservation restriction 3-0 in committee.
Further discussion? Seeing none, roll call.
Roll call on the approval of Order 215. Councilor Shan,
Yes.
Councilor Tontar,
Yes.
Councilor Vogel,
Yes.
Councilor Wallace,
Yes.
Councilor Zeid,
Yes.
Councilor Devlin,
Yes.
Councilor Khan,
Yes.
Councilor Lane,
Yes.
Councilor McCauley,
Yes.
Councilor Connell,
Yes.
Councilor Agaman.
Yes,
Motion passes unanimously.
thank you. Is there anything else, Chair Shan?
No, that's all tonight. Thank you, President, Council President.
Okay, public safety, Chair McCauley.
Thank you, Council President. Motion to approve Ordinance 59, truck routes.
Second.
Second by Councilor Lane, I think.
Yep.
Discussion.
Thank you. This ordinance is creates a new subsection, Division 8, in our Code of Ordinance, specifically for truck routes. It will create a framework that we can move forward going forward for posted truck routes. We will have to petition the Mass DOT to get the appropriate language to potentially exclude commercially plated trucks. But it begins to put some framework around this. This is response to a number of complaints in the neighborhood about commercial trucking cut-throughs on roads that are not designed for that. We've reviewed this with TSAC and the representatives there, with police, fire, DPS. Everyone was okay with the concept. As an illustrative example, Merrimack Valley Planning is will be commissioning a study in the spring on Turkey Hill Road because of excess trucking that's been there and shortcuts. So the committee had, after much debate and discussion and questioning, had recommended 3-0 to the council to review and approve this.
Thank you. Councilor Zeid.
Yes, Mr. President, I'd like to make a motion to amend to strike Water Street from 13-190A.
Second.
And I'll speak to the amendment if you'd like.
Yeah, please do.
So Water Street is not entirely in my ward, certainly, but a good chunk of it is. And it's probably one of the streets I get the most complaints about with respect to speeding. And the portions that are in my ward are actually pretty narrow. If you think about basically the Ocean Ave intersection to the bottom of Federal Street, which is the portion of Water Street that is my ward, that's some exceptionally narrow parts. And frankly, when trucks go down there, it actually ends up being more of a problem oftentimes for the trucks because they get stuck on narrow streets or they try and turn up. That's one reason that it shouldn't be on this list. And second is considering that most of these trucks would typically, be coming from 95, either off of exit 56 in Newbury or exit 57 in Newburyport. For them to get down to Water Street, it takes them down some illogical roads that are basically small side streets or Bromfield or Marlboro in order to get down. And if the goal is to get to downtown, there are certainly much better routes to take. And as a ward councilor, I just can't support having Water Street here. I'm not going to touch other people's wards. That's, everybody has their responsibility, but I can't support Water Street. So I'd like to see it stricken from it. And I'd like to ask for your support on that. With that, I'd certainly be able to support the rest of it.
Yeah, I should say, when I introduced this, I believe I said on the record that I meant to strike Water Street. That was an error. So that's my mistake that I forgot when we had the committee hearing. I just want to state for the record, it was my intention after speaking to the Ward 1 councilor to strike Water Street. So I apologize for that. I'm the sponsoring councilor. Councilors Khan and then Shan.
Yeah, thank you, Council President. I was actually going to support that as well. And my apologies for not being able to attend this particular meeting, but a couple of things and a question I had more along the up along and down along streets. I'm in this process of, I guess, our code of like our ordinance review committee and terminology and making sure we're being kind of consistent in when we do talk about directional streets. That when I looked at the code of ordinances, that's not a typically used language. So I was wondering, is there a reason for that? Because I'm just wondering, is there a reason for the up along, down along terminology?
Yeah, that's the traditional way to refer to parallel to the river. We could say parallel to the river.
No, that's okay. I mean, I'm glad you answered that because, like I said, I did a search in the ordinance and we don't refer to it. And I know we've done for parking in other places. We'll say like we'll have some other terminology, so that'll be a new one being assessed.
Yeah, but doing north and south, it doesn't always work because the river bends.
Mm-hmm.
But yes, I'm actually surprised it doesn't appear anywhere in the municipal code. It's just an old-fashioned way to refer to up and down the river.
Got it. All right. Thank you. And my other question on this is, thank you. It was helpful to hear from the chair of the Public Safety Committee that the TSAC also talked about this because these are obviously this comes up a lot. I know from the neighborhoods. And so I think that was really helpful to see that that's been vetted there too. So yes, I'll be supporting. Thank you.
Okay, so I'm going to let people go farther than just on the amendment, but we still have to vote on the amendment. So let me go to Councillor Connell.
Yeah, just briefly, Mr. President. Changing routes such as this requires a lot of consideration, and it does seem to me that if we eliminate Water Street, then access to the tannery, for example, is going to be almost exclusively down Federal Street. And it's like nailing Jello to the wall. If you drive the nail in, it squishes out someplace else. Isn't that a potential impact of this amendment? And I would like to hear from members of the committee who I'm certain discussed these different possibilities and hear what they have to say.
Committee members, let's see. Let's start with Councillor McCauley, the chair.
Sure. In response to the question from the at-large councilor, Water Street in our committee hearings was included. So we assumed that it would be trucks coming down Merrimack from 95, let's say through Amesbury, down Merrimack, through downtown to Water, and then most likely turning up Federal at that time, and not necessarily going all the way down. So this amendment, while I support removing Water Street, I know creates some logistical challenges. And if we could, when we get back to if we could amend Water Street, say down to Federal Street, I think that might be, might solve some of the tension here.
Let's see. Also on the committee, that's everyone who's on the committee. On the amendment, Councillor Tantar, are you going to speak on the amendment? You're muted. Councillor Vogel, are you going to speak on the amendment? You're muted too.
Oh, sorry, I was muted.
Oh, okay, go ahead.
Sorry, because my cat is screaming. Yeah, I had a similar concern as the at-large council, but on page 1, the third whereas from the bottom states, while commercial trucks are permitted on any municipal way in Newburyport, if they have a destination on that municipal way or nearby. So if someone had a destination of the tannery, they could go down Water Street, right? I think I'm correct. That's
I'm it's a little awkward because I'm the sponsor and the president, but yes, the way it works is these are recommended truck routes. Right now, we don't have any recommended truck routes. It's just the Wild West out there. But you can't actually ban trucks from any street without Mass DOT approval. And all this ordinance does is set up that procedure, as Chair McCauley said, that's the last section, 13-191. So trucks could continue to go down Water Street. The question is whether we encourage them to go down Green instead to get to the tannery. Councilor Vogel, how about you? Are you on the amendment? You're muted. You're muted. Now you're not muted.
Thank you, Mr. President. Yeah, that was my point as well. And I was on the verge of accusing myself here because I have a business there that's affected by trucks on Water Street, but just to make it clear, they are allowed. It's just that they're not encouraged.
Right, that's right.
Thank you. That's all.
Councilor Zeid on the amendment.
I'm all set. Thank you. Should have rolled
Okay.
my-
Why don't we do a vote on the amendment? It's just the amendment, so it only needs 6. All those in favor say aye.
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 All those opposed? Okay, so the amendment passed. Now we're back to the underlying ordinance. Were there any further discussion on the ordinance? No, okay.
Just to be
Roll
clear,
call.
Mr. President,
Yeah.
if I might. So that amendment was simply to strike the word Water Street from 13190A, correct?
Yeah, but I think as a Scrivener's thing, you can put an and in front of Merrimack Street.
Sure,
Let's just do and Merrimack Street, period. How about that?
will do.
Is there any objection? Really, don't be shy. Okay. All right, Counselor Shan.
One quick question. So to limit or ban commercial trucks, we still have to go to TSAC and then have Mass DOT do a study, and that's the process?
No. It says by order, a majority of the city council may authorize. I think out of courtesy and practice, we always go to TSAC, but no, it's by order of the city council.
Okay. All right, thank you.
Sure. Councilor McCauley.
Yeah, I just, we would not go to TSAC. I just want to elaborate on that. We would not go to TSAC going forward, but we would, to have this officially listed, we would need approval from Mass DOT directly.
Yeah, that's what I thought. Okay.
Okay. Roll call.
It's a motion to approve ordinance 59 as amended. Councilor Shan,
Yes.
Councilor Tontar,
Yes.
Councilor Vogel,
Yes.
Councilor Wallace,
Yes.
Councilor Zeid,
Yes.
Councilor Devlin,
Aye.
Councilor Khan,
Yes.
Councilor Lane,
Yes.
Mr. McCauley,
Yes.
Councilor Connell,
Yes.
Councilor Agaman.
Yes.
10 yeses, 1 aye, motion passes.
All right. Anything else on public safety?
Yes, Mr. Council President, I'd like a motion to approve ordinance 62, an extension of the residential permit zone seasonal hours.
Second.
Second.
Discussion?
Thank you. This is a change to language of an existing ordinance that simply extends the restrictions on seasonal hours in the permit zone, the residential permit zone, from May 1 through September 30th. From October 1 through April 30th, between 8 and 8 p.m. Monday to Saturday, from May 1 through September 30th. And the last part was the parking permit authorized was changed because we no longer issue parking permits, but it would need to be validly issued for this car. This was a recommendation from the parking clerk and parking team to extend these hours. From committee, it came out 3-0 to recommend.
Thank you. Councilor Zeid.
I'm just curious, to hear a little bit more of the genesis of this. I mean, I think this is a pretty big change. When we had the parking garage and all those discussions, that 6 to 8 p.m. was discussed at length, in particular for employees who were basically, one of the arguments at the time was, well, don't worry, employees, you can park, for free after 6. And I know and understand there's always tension with the neighborhoods and so forth. It seems like a big change. This covers a lot of different areas because now we have a lot of different resident parking areas. And so I'd like to hear more about what the issue is that has sort of come up. And then second thing I'd like to know about is, is the next step to basically make the resident zones, 24 and just say, yeah, it's basically, these are always resident spots and they're not open for visitors, for employees, for others. And I think at length, I think most will recall, lengthy discussions about employees, particularly restaurant employees who aren't necessarily paid very well, having to pay to park and so forth. So if this goes until 8, we had the same discussion with the police department employees at one point. So I don't know if the Ward 2 counselor, as the Ward 2 counselor, could speak to it, or if the parking clerk could, and did the PAC talk about it at all, or did it ever go there?
I'll go first. Remember that we don't have exclusive parking in any of our residential areas, except I think one. It's not in Ward 2. We have a special rule. I can't remember what street that is, but yeah. So it's still true that you get 2 hours free, even if the the parking enforcement people are standing right there, and they note that you parked at 6 o'clock on the nose. You're fine because you get 2 hours free until 8. The debate that you're remembering, I think, was especially with the police. The police were very concerned that they would have, they start their shifts at 4, I believe. So that was the debate then. The genesis of this change is really, once again, an attempt to tweak what we have rather than going to a Somerville or a Boston style exclusive residential parking. So, and I'll turn it over to Clerk Jones, who deals with this every day. But I was being lobbied, for example, by a resident on Charter Street, which of course is half commercial. And then it turns into residential as you get closer to Fair. And they wanted exclusive residential. And that was probably the straw that broke the camel's back for me to introduce this and say, all right, I want to head that off. What can we do to give relief for people, especially when they come home from work? So when they come home from work, we needed to go a little bit deeper into the evening, and it's only in summer during tourist season. So parking clerk probably not going to appreciate this, but I know, for example, especially in COVID, we're thinking of new clever ways to generate people to come downtown without getting us sick. So, maybe we could relax the rules in the winter. That would be the other side of the coin here. I haven't come in with that yet, and I think the chamber is discussing it internally this week. But to give relief to residents coming home in the evening and to head off people demanding resident-only parking, that's where I was coming from. Now I'll turn it over to Rich.
No, I think you said it well. I would simply add one thing that, remember, as it is now, if you're coming to a shift downtown, if you're smart enough and know the system well enough, and it sure seems like every parker that comes down knows every little trick, you can park at 401 and you're good, because right now it ends at 6, not 8. So again, at 401, you've got people in the know parking on all these streets, and then you come home at 5:30, 6 o'clock, and there's just no room in front of your house. And that's where the pressure comes from that Councilor Eigenman is mentioning, which I've always felt would be disastrous for downtown, which is you go to resident-only parking on the side streets surrounding downtown. It just would not be healthy. So I think it's well put. This is a measure that would satisfy some people to a greater extent. That's all I had to say.
Thank you. Other or follow-up questions also, Councilor Zeid, if you have any other questions. Because parking is always dramatic.
Yeah, no, I appreciate the explanation. I'm curious if the issue has alleviated at all with COVID, or if it's basically, I'm just questioning, is this something?
No, it hasn't. I mean, it was especially covered by, in our harbor, you heard Paul Hogg, the harbor master, but we still have this, peak periods, even with COVID. I mean, this weekend also was pretty busy. And that's when we get the complaints. Again, if you looked at it as if you're just being mathematical, you'd say, well, it's only, a few days a year or a few weeks of the year. But it's the summer when people are, all of us are trying to enjoy living in Newburyport after suffering through the winter. So that's the issue. I'm still getting those peaks even with COVID.
I appreciate it. And I don't have any more questions, but if it's all right to just comment, I mean,
sure.
I'm very, as always, very sympathetic with residents, but we've talked about this 1,000 times over the years, but, we always make these sort of one-off kind of things. And at the end of the day, the reality is where is the affordable parking for employees? That's basically the problem. Why don't they go park in the garage? Why don't they go park in the lots? And we have this conversation over and over again. Why isn't the east lot where the employee, and we've made the employee permits very inexpensive, or as inexpensive as one can. I don't even remember what they are now, a couple $100 for the year. Why? So we keep seeing this pressure, and then we still think that So is this the answer, or is the answer? And I know that the Ward 2 counselor and I, sort of grate on this, but I mean, is really the problem that there just simply is an insufficient supply of properly priced parking elsewhere, that they just say, you know what, forget it, I'm just going to go park in the garage. It's much less expensive, or I'll do the east lot. Because as the parking clerk said, I mean, everybody does know the nooks and crannies, and people do figure out what they can do and how they can do it. And so I am compelled by the 4 o'clock argument. That probably is the best one. 4 o'clock seems a little bit early, and I get that. You can skate from 4:01 to 6, and then you're good from 6 on. But I just keep feeling like we're addressing symptoms, but we're not addressing the disease. And I know that, again, we grade on that and there's disagreement on it, but I think that's the way to really solve this problem, because I think in 6 months, a year from now, you will be back to say, let's go to 10 p.m. or yes, let's make it all day, every day, and all night, but you still get your 2 hours, and then eventually that fades out too. Just my thought, living through this for several years. I'll yield.
Thank you. Other counselors? Roll call.
So motion to approve. Councilor Shan,
Yes.
Councilor Tantar,
Yes.
Councilor Vogel,
Yes,
Councilor Wallace,
Yes.
Councilor Zeid,
No.
Councilor Devlin,
Yes.
Councilor Khan,
Yes.
Councilor Lane,
Yes.
Councilor McCauley,
Yes.
Councilor Connell,
Yes.
Councilor Agaman.
Yes.
10-1 motion passes.
Anything else from public safety?
Nothing further, Council President. Thank you.
Thank you. Public utilities.
Nothing tonight.
And you get a gold star because your docket is empty. So you win.
All right.
Rules.
nothing tonight.
Good of the order. Councilor Khan.
Yes, thank you, Council President. I just wanted to let everyone know that the Ordinance Review Committee, which we had a meeting on October, I believe, 14th, and other counselors that are on that are Councilor Connell and Council President Eigerman. And just want to let folks know that we've kind of organized. I'll be chairing it, and there are certain sections that are being reviewed, and our next meeting is November 18th. And we will be having a web page similar to how the charter review was done. So I'm just gonna probably reach out to the clerk here and get a page as well dedicated to this effort. But just wanted to let folks know that was happening now. Thank you.
Thank you. Clerk Jones.
I just want to mention, if it was all right, Mr. President, with respect to elections, I would still want to get the word out there that we have early voting in person from today all the way through Friday. It's 8 to 4 Tuesday, Wednesday, 8 to 6 on Thursday, and 8 to noon on Friday. And then, of course, anyone can vote on the 3rd. If someone has a ballot, they're not sure what to do with it, they can still vote. A lot of people have taken advantage of it. And I also want to mention how wonderfully proud I am of the effort of the front office, the back office, the senior center people, the polling people. It's incredible. it's heartening.
Thank you. Yeah, no, that is a positive. Anything else? I'll take a motion to adjourn.
So moved.
Oh,
And there was seconded by Counselor Tantar. All those in favor say aye.
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 Hi.
Thanks, everybody.
Good night.
Thank
good
you.
night.